Under Virginia law, regardless of how good a case you have or how clear a case you have of medical negligence, if the case is not filed within what's called the statute of limitations, the case is forever barred. You can't bring it. You'll be thrown out of court if you do. In Virginia, the general rule is that the statute of limitations is 2 years from the date of an act of negligence by the physician or by the hospital. That is a general rule. There are exceptions to that rule, and I want to share with you 5 exceptions that come up fairly frequently. Cases in which the surgeon left behind a needle or a sponge during an operative procedure, in those cases, there's a special exception that says that the case must be filed within 1 year of the discovery of the sponge or the needle. That happens more frequently than you would probably believe. In wrongful death cases, regardless of when the physician or hospital's negligence occurred, the statute of limitations in a wrongful death case, where the allegation is that the negligence caused the patient's death, begins to run at the date of death of the patient. So it's 2 years from the date of the death of the patient in wrongful death claims. In cases involving the failure to diagnose a cancerous tumor, for example, a woman may have had a mammogram 3 years ago, and had it been correctly read, the presence of cancer would have been noted and could have been surgically excised or removed, but because it was missed, nothing happened and the cancer grew and metastasized. In those cases, failure to diagnose cancer or the presence of a tumor, the statute of limitations is 1 year from the date the patient is diagnosed with the presence of the cancer, not the date that it was originally missed, which could be years prior. Virginia also applies a rule called the continuing treatment doctrine, and that rule basically comes into play primarily with family doctors and primary care physicians. And if over a course of a number of years a doctor has repeatedly failed to provide good medical care to the patient, then the statute of limitations against that physician, be it a primary care physician or internal medicine doctor, does not begin to run until the end of the relationship between the patient and the physician. Then the patient has 2 years from that date to file a claim. The last category of exception, and there are more categories than we really have time to cover here today, but the last category or exception deals with newborns and young children. And in essence, in those cases, you have 2 years or until the child's 10th birthday to file a claim. So those are just some of the exceptions to the general rule. You should talk with your attorney about the facts of your specific case to see if you fall into any of those exceptions, or there are others that are too long and detailed to go into today.